4:05, so I'm going to get started with this. Can I welcome you all to our seminar on adaptations? It's an extremely timely and important topic, according to the English Housing Survey. In 2019 to 2020, just 47% of households that required adaptations had all the adaptations they thought they needed in their home. And that obviously therefore means that 53% didn't have those adaptations. So it's potentially a huge topic, and disabled facilities grants run around 50,000 per year. So it's a topic that affects a great many occupiers. Before I introduce our speakers, can I just make a point about closed captioning? If you want to turn that on, you can do by clicking the More tab and going either for subtitles or transcript. I think it's going to depend what platform you're working on. If you would like a transcript after the event, can we ask you to email events@Doughty Street, and then we can get you a corrected transcript. So if I can then come on to introduce our speakers. We're very lucky to have two experts to guide us through this field. First speaking will be John Hobson, who's a practitioner in our Manchester office. He's a specialist in housing and coronial inquest law, although he works nationwide, not just in the Manchester area. He's noted for expertise in disrepair claims, unlawful eviction, and antisocial behaviour possession hearings, particularly involving the Equality Act, and he's an assistant coroner appointed in 2 northern districts. Alice Irving is a former academic, having completed her doctorate about how early can we criminalise conduct. And if she ever chooses to do a seminar on that, then I'd certainly be very interested to attend it. But now she's a practitioner at Doughty Street in housing law, social care and education, with a particular focus on the rights of individuals with disabilities. And she was a finalist for the Lally Newcomer of the Year Award 2021 and a rising star in Legal 500. So two extremely well qualified speakers. They're going to speak, I think, for about 20 minutes each, and hopefully we can have some time for questions at the end. If you would like to log a question as they're speaking, then please put it into Q&A and then we can pick it up at the end. So without further ado, if I can ask John to start.
Thanks, Martin. And just to pick up, welcome everybody, just to pick up on what Martin said with those statistics from the survey. It's a timely seminar, and indeed some of the guidance that we'll be referring to draws upon what was an independent review in 2018, where there was a call from what's known as the housing adaptation sector and local authorities for clearer guidance about the local DFG, so that's the Disability Facilities Grants delivery. And certainly one of the statistics in that in 1920 to 2020, 1.9 million households in England had more than one person with a health condition that required adaptations to their home. And that review that led to the guidance, which we'll be referring to, actually is interesting, breaking down, running, as Martin said, 50,000 applications per year, breaks down into relation to how many have been run towards securing, for example, in common parts and so on. So even in that review that led to the guidance of March 2022, there's lots of really interesting statistics about the sector that we're dealing with and the huge numbers of people that this may affect. So just to go through to the first slide, the principal matter we're looking at today, the Housing Grants Construction Regeneration Act, and the DFG is what we're looking at. But also there are other routes for funding in relation to adaptations in premises, and I just wanted to reference going through and then just to really refer to what may be called an interface between how the DFG and the Care Act might work, and also with the Chronically Ill and Disabled Persons Act. Under Section 9 of the Care Act, there is a duty, of course, on local authorities to assess needs for care and support, identification of what eligible needs are. That's under the relevant regulations of care and support eligibility criteria regulations, and that will include things that overlap with DFG. For example, as we'll come on to see, the ability to use a home safely, and also reference to general living and personal hygiene, for example. There's a duty to meet those under Section 18, and to meet as appropriate provision of support plan and so on. And it's just noted that really within the guidance that's been set down, coming back time and again to the issue of consultation. Indeed, there's a duty within the statute for a local authority to consult with the relevant social services. So it might be a district council with a unitary, for example, to do that. But certainly where a social care authority, for example, thought there's a need to be determined as a need to establish the duty to assist, even where a housing authority is not able to fund or approve an application for a DFG, then it may be topped up, or it may be augmented, it may be provided under the Care Act. That's useful, those two acts there, and I won't say anything in particular about the relief duties under Part 7, of course, local authorities under 1996 in terms of suitability and adaptations in premises. If we go on to Section 1, the grants are available from local authorities, the provision of facilities for disabled persons in dwelling, qualifying houseboats and caravans, and in the common parts I've referred to of buildings containing one or more flats. Definitions are set out within the statutes you might be expect. So Section 100, disabled persons, so mental disability of any kind, sight, hearing or speech substantially impacting and so on. So there's a comprehensive encompassing there. So different to the approach under the Equality Act, it 10. But 7 certainly also in relation to a dwelling. So those of us housing practitioners coming with use of other mechanisms for redress and improvement in people's homes. We'll be thinking about the curtilage and what falls out with and within the tenancy agreement and the statute and so on. But a dwelling would include the yard, the garden, fencing, for example, enjoyed by a dwelling, those in a separate dwelling. Caravan definition under the Caravan Sites and Controlled Development Act 1960 with reference to the Caravan Act, Sites Act 68, and a yard and so on, garden around. Qualifying houseboats, a mooring in the area of a single local authority, and the right to moor such a premises, or certainly home. So just going on just quickly to further on to the next one, please. Local authorities, and if we go on one forward again. Thank you. So local authorities, I just looking at some, for example, here's Salford, distilling and conveying the information, certainly within the spirit of approach and strategic approaches within local authorities about making this provision accessible. And if we just go step 1 and then 2 as well, and there's Westminster's there. And interesting, just to note on, and it's within, because we are restricted for time in many respects on the seminar, but just to see eligible to apply owner occupant private tenants who are not council tenants, because a council tenant that would apply, there's a different route of funding within local authorities that still have their own tenants, as opposed to then bullet point 4 on Westminster's site, housing association. I think that's not clear really. Couldn't see that, for example, on Salford's. So the information is out there, and we'll have individuals who are clearly out of need will be looking to apply, and indeed they may come through and seek challenges to decision or indeed advice around it. Next slide, thank you. Made in accordance with the provisions of the chapter, particular works to be in respect of which the grant is sought, relevant works, and these are to meet a particular issue in relation to a disabled person. So the detail is contained therein of, for example, of 2 estimates from different contractors for the cost of carrying out the relevant works, and any preliminary or ancillary charges in respect to the cost of which the grant is also sought, of particulars as may be prescribed. Section 90, going on to just set out who may apply. The applicant often will not be the disabled person for whom the works are requested. Not entertain an application unless they are satisfied the applicant has or proposes to acquire owner's interest in every parcel of land on which the relevant works are to be carried out, 19(1)(a), or the applicant be as a tenant in the case of an application in respect of works to a dwelling, or in the case of common parts, the flat building, and in either case does not have or propose to acquire an owner's interest, and then goes on to talk about the caravan example of being in the local authorities area, 19(1)(c). Moving over to 5, tenant, they're covered by the principal statutes that we are familiar with, and indeed, well, the type of tenure of tenancy, so secure tenant, introductory tenant, or statutory tenant, protected occupier, reference to agriculture, or the agriculture occupancy within the meaning of Part 1 of the Housing Act 88. Tied accommodations, 5C, and a person having a licence to occupy a dwelling or a flat concerned, which satisfies conditions which may be satisfied and specified by the order of the Secretary of State. So in relation to scope, on the next slide, the DFG provides capital funding for the provision of home adaptations. And I did once upon a time, I was an economist for a number of years, different to being an accountant. So this is drawn on my very, very partial and very, very sketchy knowledge of accountancy. So expenditure on non-current assets, okay, explained as such land, buildings and plant equipment. So these are things that aren't increasing, for example, in an accounting year. If any accountants present, please do put me right in relation to that. But to qualify, expenditure must result in either the acquisition or enhancement of an asset, which with benefits lasting more than 1 accounting period. Okay, so greater than 1 year. And the guidance that's been put forward, that's come through in March 22 at Appendix A, sets out some very, very helpful examples in relation to that. And I just wanted to make a point just that may assist without being, with being aware of the danger of drawing too simple equivalences. So Appendix A in the guidance talks of identifying capital expenditure for DFG purposes, and it gives examples, and the disrepair parallel, without drawing too much of an equivalence. If we think about that juncture of scrutinising a client's case, that's an improvement, it's not a disrepair. Okay, so it's quite a basic juncture that you'll always think about in such a claim, and scrutinising that. And in this scenario, what we're doing then is looking at things that are going to improve, okay, an acquisition, a construction, or addition and enhancement of an asset, so to improve in effect the property or provide something added to it. So major adaptations, for example, facilities, could be a shower adaptation, a ramp or a stair lift. Yes, is that capital expenditure? New replacement stair lift, yes. Replacing a floor covering or repairing a shower unit, no. The reason, because the repairs only maintain the asset, they don't increase the life of the dwelling. So everything will be fact sensitive. Every case that you're looking at will be very, very particular to an individual's need, and then what is required in relation to section 1. The relevant works, that they're capital and are they captured, is an important thing to be scrutinising. So it's very, very helpful in the way it's set out, and those examples are being provided. It does get a bit, could be confusing, because routine maintenance is not classed as revenue expenditure in the example that's being given, whereas actually the provision of something new or maintenance such that life of an already existing adaptation, such as a stair lift, would do so if it extends the life over it. So that's important to be looking at and thinking about. 20, just it's on the slide already, section 20, the disabled occupant, straight forward, but nevertheless it's there because those that are applying may not actually be the person required the applications for. A certificate of owner's application. Housing Authority won't entertain the application unless it's accompanied by an owner's certificate in respect to the dwelling, and an owner's certificate for the purposes of an application for a grant certified the applicant has or proposes to acquire a qualifying owner's interest or intends that the disabled occupant will live in the dwelling or flat as his main or only residence throughout the grant condition period, or for such period as his health and other relevant circumstances permit. Condition period usually for 5 years, but there will be adjustment, there will be nuance in relation to that, because clearly adaptations may be sought for perhaps quite a time limited period if an individual, for example, is chronically or terminally ill. Section 22, again, this is really the same spirit in relation to 21, but it's in relation to the tenant's application, a tenant certificate, that it's a tenant's application, and that the tenant intends to live, if he is a disabled occupant, or the disabled occupant will live in the dwelling or flat as his only or main residence throughout the grant condition period, or for such period once more. Except where the authority considers it unreasonable, if there isn't any certificate, they shall not entertain a tenant's application unless it's accompanied by an owner's certificate from the person who at the time the application is landlord under the tenancy. So section 23 is concerned with the purposes for which the grant may be given. Must be approved subject to the provisions of the chapter, the following. Must be approved, so the application is made, facilitating access by the disabled occupant to and from the dwelling, qualifying houseboat or caravan, or the building, as the case may be, and making the dwelling or the building, houseboat, caravan, safe for the disabled person and other persons residing with him. And thereafter, within this section, going on to see, uses examples covering all kinds of scenarios comprehensively. So facilitating access, for example, by the disabled occupant to a room used or usable as a principal family room, facilitating access by the disabled occupant to, or providing for the disabled occupant a room used or usable for sleeping, access for a room where there's lavatory, or facilitating use by disabled occupant of such a facility, facilitating access by disabled occupant, or providing with a room where there's a bath or shower, or facilitating use by the disabled occupant of such a facility. And going on to the next, through talking, as mentioned earlier, facilitating the preparation and cooking of food by disabled occupant, providing a room where there's a wash hand basin or facilitating use. Moving on to talking about heating, and then also in relation to the disabled occupant, facilitating the use of power, light or heat by altering the position or means of access or control, and so on in relation to that, or providing additional means of control. And over again to facilitating access around the dwelling. Okay, so within and to enable her to care for a person who is normally resident there and is in need of such care. And one of the cases that we'll look at just in due course shortly concerned an application in relation to provision for a child, for a conversion of a loft, such that that child would sleep away from siblings because of the risk to others, to the siblings, through the nature of the difficulty, the disability, and the condition. And so that was an example, and for various reasons, there was a refusal and a challenge, which was indeed successful. And I'll come back in relation to that. I'll just refer to that in passing because the casework picks it up. Is maybe called the gateway provision that needs to be looked at first. What is the purpose for which the grant is being made? Is somebody qualifying? Remember, it's mandatory, and then there will be a provision, a consideration in relation to section 24, which talks about well, there's further scrutiny about necessary and appropriate to meet the needs, and is it reasonable and practicable. Before I go any further, just on the next slide, there are various restrictions within the Act itself. So, for example, so we go to slide 20, restriction on grants for works already begun. And this means testing in the case of an application by an owner or occupier. The statutory maximum for the grant itself, by way of the order in 2008, is 30,000, and so what may be available is reduced accordingly to means testing. There may be, in an application, if it is granted, may not take place immediately, but it must be done within 12 months. And so the issue within determination, for example, non-consideration of an application would be a ground for a challenge. Similarly, with the 12-month, for example, if there's the assertion of the grant being provided, but it's not within that 12 months from the date of notification of being granted, then that would be another challenge. The application itself, so on to the next slide, is we see comprehensive within the guidance itself, eligibility, means test, the specifications required, planning permissions, tendering, and service contracts as well. And that's useful, again, to look at the detail within the guidance that's been provided, to go through those aspects and to see what may be included in the application, about what may be the costs that may be incurred. So, for example, a variety of matters which, for example, permissions or drawings, and the finer detail of a particular application and what is required. I wanted to then just talk just briefly in relation to something that's covered comprehensively in this guidance, which is what's known as assistive technology. And as the quote that I've pulled out there says, products or systems that support and assist individuals with disabilities, restricted mobility, or other impairments to perform that what typo, it's my fault, might otherwise be difficult or impossible, may be included as part of a DFG award package to maximise benefits of home adaptations. And that's covered within Chapter 7, and it's helpful to in relation to that. So we're looking at matters such as smart lighting, as it can be called, remotely turned on and off, smart hubs that are people allowed to control household devices, voice activation, for example, or via an app on their phone, infrared controlled power sockets, for example, take another example. So we just look at the various headers within that section where it gives examples of works that may be requested. So preparation of food. This is an example of an assistive technology, adapted height and adjustable cooking surfaces, for example. Access and use in the bedroom. Control of power, light and heat. And then there is this distinction, and again, the guidance is helpful, 710, because it may well be that whilst the infrastructure, if you like, to put in the assertive technology can be part of a DFG, thereafter, if you're going to have to renew a Wi-Fi membership or cost, if you like, if you will, that wouldn't be covered. But nevertheless, there may be other routes and sources of support that run in tandem. So, for example, there may be different ways in which that may be supported. It could possibly in relation, for example, in the Care Act, to use that example again, but also within funding, within a housing assistance policy, which is also at the heart of the approach, a strategic approach about what local authorities must do, and their approach thinking laterally and holistically in relation to support itself and for disabled individuals. So just moving on to section 24, the approval of the application, it will approve subject to the following provisions. Where an authority entertains the application, proposes to acquire a qualifying interest and so on, shall not approve unless satisfied 3A, the relevant works are necessary and appropriate to meet the needs of disabled occupants, and B, that it is reasonable and practicable to carry out the relevant works, having regard to the age and condition of dwelling, houseboat and so on. And importantly, and this is the duty there within, in considering the matters mentioned in paragraph A, the local authority, which is not itself a social services authority, shall consult the social services authority. And that's set out, referred to in consideration of what is necessary and appropriate, paragraphs B 61 to 83 there, as I've specified. And so there'll be involvement, consultation, involvement, for example, with occupational therapists and assessors, and the costs and so on being appraised and put together to answer that question, to consider whether something is necessary and appropriate, and indeed, is it reasonable and practicable. And just to finish, case law in relation to considering Calderdale is the case in relation to the decision relating to a proposed conversion of a loft in a separate bedroom for a child with a form of autism. In this case, there was consideration of not the absence of risks of the others in the house, but actually to reduce it as far as reasonably practicable, if not possible to be eliminated. So that was one interesting issue on the facts of that case. But the actual point that was dealt with by the Court of Appeal was that the approach within the decision of the local authority was that conflation of section 23.1 and section 24.3. 23.1 is a gateway provision, 24.3, necessary and appropriate, is a control for applications that pass through the gateway. I think that's a really useful case. It's useful on its facts, and it's useful just to see the approach that is required to be taken, and then of course to examine that in a decision if there's a refusal. And finally, McEwen, I'll just skip through that because I'm really conscious of the time. McEwen and Islington, where considering what is appropriate and necessary, the local authority was going wider than actually what the specific purpose was for the request and the application. So not to say, well, it's not, if you look at it in a wider context, this request for this, it was a platform that moved up and down as opposed to a stair lift, wasn't necessarily appropriate, but they were looking wider than that actual narrow, what was the purpose, what was the aim, what was the objective of what was being asked for under the DFG. And so there's a summary on the next slide, but I won't take your time with that, but it just summarises the aim in relation to the guidance that's been provided, and that's really what I wanted to say. There's a lot in there. Thank you.
Thank you very much, John. I'm going to pass straight on to Alice.
Certainly, I think I better get cracking. I'm mindful of time, and I'm sure we all want to drink on our hands at 5 o'clock in this sweltering heat. Thanks very much, John. Here's more statistics, because we love statistics on a Wednesday afternoon. I'm going to be talking today specifically about what happens if, for example, you've got funding, but you're a tenant and you're having difficulties in relation to getting your landlord to agree to allow you to make adaptations to the property. And here we've got some statistics about the fact that there are real barriers to people who require adaptations to property being able to access property. And it might be once you're in property, adaptations are not consented to, or it might be that you're looking at a property and you ask the landlord as part of that process, well, would you let me make adaptations? And then they refuse to let that property to you because of your accessibility needs. But it's quite clear that 79% of landlords don't actually know that funding is available through the Disabled Facilities Grant, and that it might not fall at their door to fund these things. And I think there is a real need for greater awareness around these issues in order to start to address what is effectively systemic discrimination in landlords' practices in this area. So if I can come through the next slide, please. So John touched on this briefly. I'm not going to spend very long on this because this isn't the interesting bit. There are some technical requirements you need to hit if you are a tenant and you're applying for a Disabled Facilities Grant, and that relates to the tenant certificate and the owner's certificate. The only thing I would say is that under the legislation, a local authority administering the Disabled Facilities Grant can waive the requirement that you get a certificate from the owner of a property if they think, for example, that your landlord is unreasonably withholding consent to the adaptations. So that's something to flag. If, on the other hand, your landlord is really on board and that they're all up for making their property accessible, recognising that there's actually quite a large cohort of people who might be able to rent that property going forwards, you might even consider asking the landlord to apply for the Disabled Facilities Grant in their name. But generally speaking, we're not that lucky with landlords. I just note there that in the guidance, which is online, and that's the Disabled Facilities Grant guidance, if you just Google that, which was updated in March this year, there's some information there about the kind of benefits of the landlord making the application instead of the would-be disabled occupant. But I'm going to crack on, so if we can come to the next slide, please. Right, so the first thing you need to know is that under the Equality Act, and particularly Section 190, there's actually a provision expressly about a tenant or a disabled occupant, if they're not the legal tenant of the property, asking for consent to make improvements to their property. And you'll see there that when we talk about relevant improvements, we've got a definition which relates to basically facilitating a person with disabilities enjoyment of the premises, which is a very broad definition. And we'll be talking about any alteration or addition, including in relation to fittings or fixtures. So something like a fixture, like a rail in a shower, right through to something more significant, like a through floor lift or a chairlift upstairs would fall within this relevant improvement definition. So if we can go to the next slide, please. So basically, if you're a tenant and there's provision, for example, in the tenancy which says you can make improvements to the property with consent, then you must ask your landlord for consent, and if they refuse that consent, written reasons must be given. And so that's a statutory requirement. So a landlord can't just say no without any reason. In addition, if they fail to respond to the request within a reasonable time, this is the third bullet point down, it'll be it will be confirmed that they've basically unreasonably withheld consent. That's automatic under the legislative framework. If, on the other hand, they say no and their reasons aren't any good, you can argue that the consent was unreasonably withheld. And at that point, the effect of the legislation is to say, well, it's to be treated as if they did consent. So if they say, we're not going to consent to you adapting property, here are our reasons, and those are unreasonable reasons, then it is to be treated as if they've actually, in fact, given consent. Importantly, the burden of proof, if there's any kind of argument about this, it's for the landlord to show that any consent was reasonably withheld. So they have to show they've got reasons for not agreeing to adaptations. The kind of things we'd be looking at very fact sensitive, that might relate to impact on the value of the property in the long run, the feasibility of being able to let it to other tenants, any kind of concerns about whether or not any works or adaptations can be reversed easily, and this sort of thing. In addition, you might sort of throw in the balance there the kind of overall impact on the individual person who needs these adaptations. Now, I would note that Section 190 expressly doesn't apply to secure tenancies, which can give people pause for thought and say, well, that doesn't seem right. If you've got a secure tenancy, surely you should have the same kind of rights. Rest assured that those sections of the Housing Act 1985 that are at the bottom of the slide there provide a parallel procedure, which effectively enable you to go through the same process of asking for consent, and if that consent is unreasonably withheld, you've got some remedies there as well. So the first point to make is that you can ask for consent from your landlord, and these provisions might assist you in being able to get around that if that consent is unreasonably withheld. Can I have the next slide, please? I think it's probably quite obvious that we're going to be concerned as well with potentially a claim for a failure to make reasonable adjustments if a landlord refuses consent to allow you to adapt the property. Unfortunately, there are some fairly technical aspects of the Equality Act to navigate in order to make sure that when you're advancing this kind of claim, you do that properly and thoroughly. And I'm going to try to, there's a lot on these slides in terms of technical detail, and I hope that they will be of assistance when they're posted online later for those of you who have to think about this in the future. I'll try to do this quickly and an overview now. The key thing to note is that for most cases, and this might in certain cases not be right, and I'll flag that later on, but in most cases will be in Part 4 of the Equality Act, the premises section. Section 35 is your gateway. The person who manages premises must not discriminate against the person who occupies those premises. And that includes direct discrimination, indirect discrimination, discrimination arising from disability, and a failure to make reasonable adjustments. They also can't harass or victimize a tenant. So I'm only going to talk about failure to make reasonable adjustments, but it's always worth, when you get a case of this sort, thinking about, for example, whether there's harassment, because often that's pled in parallel, or there might be indirect discrimination, or discrimination arising from disability. So just make sure you consider all of the kind of bag of different forms of claim you might be able to bring. Next slide, please. So Section 36 tells us that a person who controls let premises has a duty to make reasonable adjustments. You'll notice at the end of Section 36(1) that it also says a person who's responsible for common parts in a building. So imagine a flat block, for example, where there are common areas, hallways, stairs, shared entranceways, has a duty to make reasonable adjustments. This can trip you up really easily. That part of the legislation is not currently in force. It's never been brought into force. So currently there's no duty on a person who, say, manages a building to make reasonable adjustments to common areas. And that's a clear gap. In the most recent Disabled Facilities Grant guidance, it's made quite clear that the government does intend to bring that into force. And in fact, you'll see a link there that there is currently a consultation open if you wish to respond to that, to say, yes, please do bring this in to force, because obviously this is important for disabled people. And there's a link there, and that consultation is open till August. So I encourage those of you, if you're able to follow through that link after this and contribute to hopefully getting that section into force. Next slide, please. So what is the duty to make reasonable adjustments? I think all of the bits of the Equality Act, this is a bit which we can tend to be a bit sloppy with as lawyers, and I mean myself as well as anybody else. I think because the idea of reasonable adjustments kind of has a public or common understanding that's a bit different from the law. We tend to think, well, if somebody needs help, if they need something, that's a reasonable adjustment. And we can forget sometimes to look at actually what the duty is as defined in law and to make sure that we satisfy it. So a duty to make reasonable adjustments comprises of 3 requirements. So there are 3 potential limbs of the duty to make reasonable adjustments. The first is that the person who you're alleging is discriminating applies a provision, criterion, or practice. So they might have a policy or they might have a practice of doing something. And that PCP, as it's often called, disadvantages a disabled person substantially. Now, substantial is defined elsewhere in the legislation as more than minor or trivial, in a relevant matter when compared with a non-disabled person. So it's really important to say, well, what's the PCP? How does it disadvantage disabled persons in a way that is different when compared with a person who doesn't have that disability? And if you can show that there is that difference in disadvantage, then there's an obligation to take reasonable steps to avoid that disadvantage. The second bit of the duty to make reasonable adjustments is where there's a physical feature that creates that disadvantage. And again, then the duty arises. And the third is that if an auxiliary aid weren't provided, that there would be that disadvantage. And again, reasonable steps are required to avoid that disadvantage. So Section 20 of the Equality Act sets out the kind of 3 ways in which there might be a duty to take reasonable steps. What's really important is that all 3 of these limbs of the duty don't apply in every context under the Equality Act. And that's buried in the schedules of the legislation, the fact that sometimes not all of these apply, and it's very easy to miss. So if we can come to the next slide, please. When it comes to Part 4, when we're talking about management of premises, we need to look at Schedule 4. Schedule 4 tells us more about what the duty of reasonable adjustments entails in this context. And what it says is there's a duty to comply with the first and the third requirements. Now, the first requirement related to PCPs, the third requirement related to auxiliary aids. You'll see that that doesn't refer to the second requirement. And the second requirement is if there's a physical feature that causes disadvantage to a disabled person. So on the face of it, we've got a problem here because adaptations, by and large, are generally about physical features of properties that cause disadvantage to disabled people. And what Schedule 4 says is, well, that duty doesn't apply when it comes to the management of premises. And that sort of is hammered home even more by paragraph 2.8 of Schedule 4. It is never reasonable for A to have to take a step which would involve the removal or alteration of a physical feature. And there's a bit of kind of detail there about what is and isn't a physical feature that's worth looking at there. You need to look at both Section 2010 and cross-reference that with Schedule 4, Para 2.9 to get the full definition you're working with. I don't have time to address that nuance here, but just that's on the slide there. Next slide, please. So are we stuffed? Does it mean that I can't say there's a failure to make reasonable adjustments if my landlord refuses to allow me to adapt my property? Fortunately, the answer is no. We can instead argue that a landlord might apply a practice criterion or say a policy, a PCP, that says, well, I won't consent to these kinds of changes. And it might be, for example, that your lease agreement, your tenancy agreement says you're not allowed to make adaptations to the property. And what Schedule 4 also says is that a term of somebody's lease can be a PCP for the purposes of the Equality Act. And also that if a term prohibits alterations being made, they are required to make reasonable adjustments to that term to enable a disabled person to avoid a disadvantage arising from a term that stops them from adapting property. So what does this mean in practice? Can I have the next slide, please? I'm going to come back to that one if we can go to the next one, please. So all of this was thrashed out in a really helpful case called Smales and Clewer Court Residence. Now it's only county court level, So it's not binding, but it is from a circuit court judge. And it does include some really helpful information. And effectively, in that case, there was an individual who had a tenancy, and that tenancy said you can't make adaptations in the property. But there was a practice exercised by the landlord or the management company in question of sometimes giving people permission to make adaptations. So they said, can we please have permission? The defendant said no, and they sued them in relation to discrimination for failure to make reasonable adjustments. We get to the county court in Cardiff. The landlord says, well, you can't require us to make adaptations because that would be changing a physical feature. And if you ask us to consent to adaptations, that's basically the same, so go away. The claimant says, well, there's a bar in the legislation to you being required to make the adaptations yourself, but there's no bar on you consenting to them. And consenting to them is not the same as being required to carry them out yourselves. And so it would be a reasonable adjustment to require you to consent. And the claimant won. So what this means is that while there's no duty to make reasonable adjustments, which entails you can require your landlord to make the adaptations themselves, it might be reasonable to require them to consent to allow you to make adaptations. So if you've asked for consent to adapt the property and you say, I've got my disabled facilities grant or other pot of money that enables me to do this, the landlord says no, you've got a couple of options. You can look at section 190 and you can say, well, was that consent unreasonably withheld? Or you can look at reasonable adjustments and say, was a failure to consent a failure to make a reasonable adjustment? If I can just go back a slide. One really, really important thing when we're under premises, and this is again buried in a schedule, the duty to make reasonable adjustments only arises if the tenant or someone on their behalf requests those reasonable adjustments to be made. So in other contexts, the duty is anticipatory. So I don't need to ask. You're just meant to think about the fact that disabled people might want to come into your shop, and you've got to anticipate that. That's not the case when it comes to the premises part 4 section. So for lawyers, whenever you get one of these cases, one of the first things you want to be doing is making sure you put in a very clear request for the reasonable adjustments you are seeking, and make sure that you're referring to the Equality Act so that you don't get tripped up by them turning around and saying you didn't ask. And often people aren't aware of that, and it will come to council and we'll look at it and say, we've gotten sort of a year in and we've not asked in terms for what we wanted. If I can go to the next slide, please, and I'll finish off. Down the bottom there's a very passing reference to a complex legal point, which is, I've said all this stuff about the limitations of part 4 of the premises, which is you can't ask for reasonable adjustments, which would require a landlord to carry out works themselves to change physical features. And you have to ask for reasonable adjustments. The duty isn't anticipatory. When it comes to part 3, which applies to services, so where somebody provides services to the public or part of the public, those kind of limits don't apply. So the duty is anticipatory, you don't have to ask, and the duty includes a duty potentially to alter physical features. So if you can get yourself into part 3 instead of part 4, that might be a benefit to you. Plumber was a case with a tenant, and very briefly, it was a fairly wealthy tenant. The managing sort of body in their building also owned a fairly exclusive club in the building, which you could be a member of, and you could access a swimming pool and a spa. They said they'd failed to make reasonable adjustments to enable the claimant who had MS to access the swimming pool and the spa. And the argument between the parties was, well, if it's premises, you can't make me make those adjustments to the building. And they said, no, this is a service. And the court agreed it was a service because people could join the club who weren't only members or weren't only tenants of the building. Some people who weren't tenants of the building could also access the club. Therefore, it was a service being delivered to the public more generally. And for that reason, it fell under part 3, and they were required to make changes to the building, and their failure to do so was discrimination. So just be aware of the fact that you might want to try some fancy footwork in relation to part 3 versus part 4. Now I'm going to take a deep breath. That was a lot of content, and I know I've spoken at a real clip, but that brings us to questions. I can see that there's one in the chat box. So are you happy for me just to have a crack at that, Martin?
Oh, well, there's two questions, I think. There's one in the chat box and one on Q&A. So the one on Q&A, there's one on Q&A that is specifically to you, which is, does Smales include refer to an adjustment which came in at no financial cost to the landlord?
Yes, so the point of Smales and Kluwer is to say you can't require the landlord to carry out the work themselves. What you can require the landlord to do, potentially, if it's reasonable, is to consent to you carrying out the work yourself. And so in that case, the proposal to carry out works was to be done at the cost of the tenant. And that's where it's sort of a two-stage process. That the first bit that John covered, you're going to want to think about, how can I get my hands on some money? That might be disabled facilities grant, it might be through some of the social care legislation he identified. And then the second step might be, well, I've got my money, but my landlord's being a stick in the mud. What can I do? And that's where these Equality Act provisions I've identified can help you. Often a letter to the landlord setting out these arguments, and often landlords don't understand that there are obligations. They can't just say no. Might get things moving without a need to issue a claim in the county court for discrimination.
There was a query which I don't know if people have seen, but it's been answered. From the question was, for DFGs, are there any restrictions on immigration status? And John answered that by noting that the same housing benefit persons from abroad exceptions apply. Just one question arising out of that, though, John. I mean, if that doesn't mean, though, does it, that it's not like right to let type situation. So if you were a qualifying applicant as an owner and you made the application, then it wouldn't be disqualified just because the person who was going to take advantage of it was someone from abroad, would it?
Let me unmute. It's actually, if it's made for an owner and it's for somebody who is a person from abroad, then it's excluded too.
Right, I see. So
it's in the guidance. Yeah.
Then they're excluded as well.
Yeah. So it's that section on the guidance, I think. Just let me go back to the Q&A again. It's B39. It follows through. It cites those regs. An applicant can't be an applicant if made on behalf of an applicant who is a person from abroad. So.
Right. Okay. And then there's another question for you here. Whether an authority can have a policy unwritten of only proceeding with adaptations that are considered mandatory. Well, there's a problem about them having an unwritten policy because it won't be transparent. But
they also can't fetter discretion, can they? So obviously, if it's a disabled facilities grant and it falls within the mandatory grounds, they don't have a discretion, but they also have discretionary powers under other bits of legislation, and they'll have to apply that legislation properly. And they can't have a blanket fetter that just says we'll never consider it, because that would be an unlawful fetter of discretion. So sorry, Martin, I cut across you there. You're quite right as well that something that's unwritten is a massive problem.
John, do you want to add anything to that?
No, I think that's right.
All right, another one for you, John.
Right.
What's a reasonable time in section 190 to give a response to a request for improvement? No, sorry, it's for you, Alice, isn't it? I think.
So I did have a quick look at this. There's not actually any helpful case law directly on section 190 I could find, and there's nothing in the guidance itself that I could find. I think it's probably going to be a little bit dependent on how complex the improvement that you're seeking to make is. So if I'm asking my landlord, can I put a rail in my shower, that's going to, I would expect, be maybe a 4-week turnaround or something like that might be reasonable. I'm literally putting my finger in the windows there. But if I'm asking to install a through floor lift, that's kind of a different proposition, and you might expect that they would a reasonable time scale might be affected by that. Similarly, one thing I didn't outline is that sometimes where you've got a block of flats, each of the tenancies might have parallel clauses saying nobody else can alter things. And if you've got multiple people who might be affected by a change in a flat, that might be something that sort of impacts on the reasonable kind of time. But I would say, if it's a very straightforward adaptation, and often, there are significant gains that can be made for people with fairly small adaptations often, that you expect a pretty quick turnaround. But public law mean?
DFG 6 months. It's more fastened down on that. Yeah.
Well, we have a little.
Alice, I don't know if you're breaking up quite a lot. I wonder if it's your end. I don't know if that's a common feature with everyone or whether it's just my link.
How much of me did you miss? My apologies, everyone.
Quite a lot of what you just said, I'm afraid.
Oh dear. I can say it pithily. Am I clear now? Yes,
you are, yeah.
So it will depend on what the adaptation request is. If it's a simple adaptation like a rail in a shower, I imagine you would expect to turn around quite quickly. If the request is something like a through floor lift, or it might impact on neighbours or other people in the building, for example, have clauses in their tenancies that impact on what neighbours can do, that timescale might be longer. I've not identified any helpful authority.
Okay, are there any other questions or contributions that anyone wants to make? Or any further points that Alice or John want to add?
I might drop a couple of things in the chat just for reference. So I've just put a link that everybody should be able to see in the chat, which is the updated guidance. And John did mention in passing that chapter 7 in there refers to assistive technology, and that's a new addition that's only come in, and that's a really sort of clear new feature. And below that, I've linked to a report that was prepared by a think tank who's part of an all-party parliamentary group. And this was the report that in part underpinned some of the recommendations that led to that change in the guidance. And that might be useful. It sort of sets out smart homes for independent living, and it sort of sets out the ways in which technology might be relevant. And I think it's a good read if you're interested in thinking about, well, can we think creatively about how we can use these funding pots to improve the lives of our clients by looking at the sort of technology options that are now clearly covered and referred to in the guidance that's just been reissued.
Thank you. There's one other question in, which is if your landlord doesn't answer, but you don't want to run the risk of an adaptation being reversed, can you seek a declaration from the court that the landlord's treated as having agreed to the adaptation? I think the answer to that is yes, isn't it? Yeah,
it must be, because I mean, that's the effect of the Equality Act, but I can't see why you wouldn't be able to apply to the court for that.
I mean, you can do the same. I mean, that's what you can do in general landlord and tenant cases where you've got a qualified the adaptations clause. So it would be discriminatory to apply something different under the Equality Act. But and of course, if they so, and it's an important point, because obviously you don't want to spend a fortune on adaptations and then find that you get your lease forfeited because you did it without consent or something.
Yeah, that's a really important issue, and you'll actually see in the Smales case that the claimants there started works and then were required to stop by the landlord, and that led to a fairly negative relationship between the parties and findings of harassment actually on the part of the landlord's body. And so I think it's, you know, if you try to kind of get everything clear also for the value of the relationship, because obviously if you've got neighbours who are there and you're planning on living in the home for a long time, that's a significant impact on your client if you've kind of run roughshod over what they feel are their rights and you've damaged that long-term relationship. So I think it's always good to have everything in line to start with, if at all possible.
Okay, thank you very much. I mean, we've run over a little bit, but there's been a huge amount to cover, and our speakers have been extremely impressive, not only in their knowledge and skill in presenting all of this, but also keeping it in such a short time frame. So thank you once again, everyone, for coming. And a reminder that if you want a closed captioning transcript, then please email us at events@Doughty Street. And it only remains for me to ask you to have a virtual round of applause for our speakers. Thank you very much.